25-9352FH. It's on our docket for a sentencing and also a show cause, but I think I dismissed that show cause, so that should get off the docket. So we'll do just for sentencing, possession methamphetamine. Mr. Holder, have you had a chance to review the pre-sentence report recommendations with your friend?
Yes, I have.
Any additions, corrections?
No.
The advisory guidelines are scored at 0 to 11 months. Any scoring challenges?
Yeah.
Mr. McLennan, any additions, corrections, or scoring challenges from the people?
One moment, Your Honor. I believe I have a scoring challenge on this one. Yes. Your Honor, the people had challenged OB12 and OB15.
Okay, well, let's do them one at a time here. OB12. What's your challenge?
OB12 calls for 2 contemporaneous felonious criminal acts involving other crimes that were committed. The PSI scored OB12 at 1 point. The people would assert that it should be scored at 5 points. The 2 contemporaneous felonious acts that we would argue would be based on the evidence of the file computer to commit a crime and delivery of methamphetamine. There is no raw rule for OB12, so I believe case law states the court must consider conduct that did not. As far as the delivery, the confidential case, the CI traveled to meet with the defendant at a location from the defendant's residence. At that location, the CI.
Sure. Well, I think that the delivery is the basis for scoring 1 point for one contemporaneous felonious act. That there was another delivery, right? There, or the delivery. But what about the? Isn't using a computer to commit the crime the same act?
Well, in this case, prior to the delivery occurring, the phone was used, Facebook Messenger and phone placed between the CI and the defendant to arrange the meetup location for the delivery.
Mr. Vogler, your position?
Your Honor, I was assuming they were using the dismissed computer charts scoring for 0.1 for the 1 point, and trying to use the delivery. I think it would be barred by the holding of People v. Light, which was decided back in 2010 at 290 Mishap 717, picked up again by People v. Carter 503 Michigan 221 2019. And just to quote a little bit from the Supreme Court case, they indicated that a determination of whether an offender has engaged in multiple acts for purposes of OB12 does not depend on whether he or she could have been charged with other offenses for the same conduct. What matters instead is whether the sentence offense can be separated from other distinct acts. When we look at OB12, 2 things have to happen for it to score. The criminal act must have been contemporaneous, that is, within 24 hours, and the criminal act will not result or has not resulted in a separate conviction. Here, illegal possession of methamphetamine is a necessary included lesser offense of delivery of methamphetamine. That, I don't believe you can use the illegal possession twice to gain another act under OB12.
What about the computer crime?
That one is so
because I see the prosecutor's point that she used the computer device prior to, so you could chronologically separate it out a separate act. But what would make that act a felony by the charge is used a computer to commit the crime.
The only way that comes into play is, and it's really a tough one in my mind, but I'd always assume that the computer using it would be in situations such as looking at storing, retrieving, sending child pornography, using it to steal identity, using it where the action of using the computer is actually the commission of the crime in question, whether it's fraud, identity theft, those types of things, as opposed to sending a text message, hey, I'll meet you on such and such a day,
Yeah. So do you think it's properly scored at 1 or 0 or should be 5?
It probably should be 0, but
none of those itself changes the range, I understand.
In and of itself.
All right, Mr. McLennan, any rebuttal argument?
No, Your Honor, I think I covered it already with my previous comments.
Okay, I think OB 12 is designed to cover separate felonious acts. And here we have really one act is arranging for a delivery and making that delivery of meth using a computer device. It resulted in 2 separate charges using the computer and the delivery. But then it was pled to a single felony of possession, which is a necessarily lesser included offense of the delivery. And the use of the computer was all wrapped up in that same act. I don't really see that there was a separate felonious act committed. So I'd actually score OB 12 at 0 points. All right, Mr. McLennan, you had a challenge on OB 15.
Yes, Your Honor. The offense involved the delivery or possession with intent to deliver a controlled substance. I think the facts indicated this one. I guess first I would cite 2 people v. Jackson, 497 Mich. 850, 2014. Case was scored for OB 15 when there was evidence of the delivery of drugs. Case as well, I think the record has evidence, or rather the police report and facts contained there and have evidence of the delivery of methamphetamine, which I kind of just rely on that again and believe that that should be scored at 5 points.
Thank you, Mr. Volker.
Ask the board to continue that score of OB 15 at 0. I'm relying on People v. Gray. That's a Court of Appeals case in 2012. 297 Mishap 22. I thought the holding there in that case involved, if I recall correctly, a gentleman with quantity of methamphetamine in a motel room. At the same time, he had a quantity of methamphetamine in a vehicle that he was driving when he got pulled over. He got charged on and convicted of what occurred as to the meth that was in the vehicle. The quantity that was in the motel room, that separate charge, but case prosecution wanted to get more points based on the quantity overall, possession quantity, adding to it what was in the motel room. And then Gray said, no, we're only going to look at this offense that the court has before it, and denied that, and that is how it stood. I think the grade comes down. There was a People v. Drake. It's an unpublished case, but I thought it sort of summarized Gray pretty good. And if I could just read it slowly to the court, because it's quoting right on the case as it is. OB 15 requires a court to separate the conduct forming the basis of the sentencing offense from the conduct forming the basis of an offense that was charged and later dismissed or dropped, regardless of the sequence in which the conduct transpired. In other words, a trial court may not consider conduct resulting in dismissed charges that are not part of the sentencing offense. An assessing points for OP 15 because it would be fundamentally unfair to allow the prosecution to drop a charge while brokering a plea bargain, then resurrect it at sentencing in another form. And I think here that OB 15 is very tightly drawn. This is the sentencing offense. This is what we look at. And there's no delivery in the sentencing offense. Nor could you argue that the amount possessed or was under circumstances of trafficking, because this is a one deal situation. There's no evidence of any trafficking, and which is, by the way, defined by the statute governing OB 12 or OB 15.
Yeah, there wouldn't be evidence of trafficking here to be the Mr. McLennan, any rebuttal argument?
No, Your Honor, just that I think there is evidence of additional conduct past just 15 rather.
Okay, well, the language of OB 15 counsels to score 5 points if the offense involved the delivery or possession with intent to deliver marijuana or any other controlled substance. Then there's the separate part, or possession where there's evidence of trafficking. Trafficking is defined as sale or delivery on a continuing basis to one or more other individuals for further distribution. So it requires like sort of 2 steps up. There's no evidence of trafficking here. So if this was just a possession, then 5 points wouldn't be scored. But the Supreme Court has held that trafficking only applies to possession, not to the delivery or possession with intent to deliver. And here, the language of the guideline is the offense involved the delivery or possession with intent to deliver drugs. Not that the offense was delivery or possession with intent to deliver. So the involved is broader language. I think that means that where there is a delivery and it's pled down to a possession, that then, the prosecutors, or I'm sorry, Mr. Vogler's right that People v. Gray says that OB 15 is a McGraw variable. But the language of the statute is that it involved. In that case, that was a possession case that they were trying to look at other drugs that were dismissed. There's one event. There's one, as I just said on OB 12, there's one felonious act. And that act, sentencing offense is possession, but that act was the delivery. So that this possession did involve a delivery. So on the basis of the statutory language, I would score OB 15 at 5 points. So that brings the total OV at 5 points. It still is OB level 1, so that doesn't change the range. All right, Mr. Vogler, anything you want to say on behalf of your client?
Oh, yes. Your Honor, it seems to me, based on everything that we know about this case, is that this was a one-time occurrence. It never would have happened if my client had been just going about her life. The person, this thing was a controlled buy. The person that made the buy was in trouble themselves. She was a friend of my client's. My client, in her words, helped her out. So that happened. It happened on March 6, 2024. The police approached my client, about 5 months later on August 28, 24, to interview her to see if she would want to work for the police. And my client's response really was to the effect, like, I'm clean. I've been out of that. It would look really funny for me to go around and approach people to buy something when I'm out of it. And there wasn't a warrant authorized till November 5th of 24. She wasn't arrested until February 11th, 2025. And so here we are today. I know that from the information I've received, candid information, that the officer in charge of this offense did not believe my client was a drug dealer. I don't think she was in their sights. She's been in a methadone clinic for the past 8 years, working her way down slowly from the quantity of the dose that she receives. She hasn't had any problems since almost a year and a half ago on this. I believe that there were attempts to come back after that March 6th to make further buys, which did not happen. And that there were requests before that date by the same person that did not happen. So this is a situation where we've asked for, and there's been an agreement upon with the prosecutor, the disposition under 7411. I think my client, confident she's going to be able to successfully complete that. I think she intends to go out and look for work. I think she's put that off because of this thing that's been hanging over her all this time. And probably that'd be one of the better things she could do, is to go out and have work, get her out from her house, expand her life out a little bit more. But ultimately it comes down to this, in my opinion. This doesn't happen but for a controlled buy being made on her. It just doesn't happen. Not that she wouldn't have gotten caught, but there wouldn't have been any uncaught sales. That's all I'm saying.
Okay. Thank you, Mr. Brooke. Ms. Parr, you don't have to say anything today, but it is allowed. Is there anything you want to tell me or no?
I'm not a very good speaker. I do want to say that I have drug swings here. Since 2016, I've been in recovery. That's where I plan on being. That's what I want. This shouldn't have happened. there was a slip and I'm up stronger than ever. I'm too old for this. I know what I want in life. And it's been recovery. That's it, Your Honor.
What was going on with that meth use?
She was a really close friend of mine.
No. I don't mean the CI. I mean, regardless of the delivery, you had some to deliver, which tells me you were using some methamphetamine.
There's hold on. I don't know what to say at this point. I was using, yes. I had a year.
That's what I'm getting at. That you were using them.
I was using with her. It wasn't happening until she came around. I thought I was strong enough in my recovery to help somebody out. She was doing good for a long time too. So it was something I was trying to help her out of, help her with, and I just got sucked into it.
Thank you.
Your Honor, could I?
No, Mr. Parr, you don't get, Mr. Parr, stop talking or you're going to jail.
Okay.
I'm trying to tell you, you don't get to talk. Okay, 1 day jail. Mr. Parr, you're gone.
I wasn't trying to sway anyone to say that. Anyone's judgment to say that. I was just
1 day jail, contempt of court for disrupting court. That's an immediate disruption and contempt in the presence of court. Mr. Parr is found in direct contempt of court and ordered 24 hours in the Prescott County. The court will prepare a judgment.
I was getting respect.
You want more time? Keep talking. If you keep disrupting, you're going to get more time.
Respectfully talk to me?
48 hours. 48 hours. Continue direct contempt and interruption. Mr. McLennan, recommendations?
Thank you, Your Honor. Ms. Parr is 41 years old, 7 prior misdemeanors. It looks like this would be, she has no prior felonies. She does have a history of substance abuse. I would say, I do think this is kind of a unique, I see so much potential for Ms. I really do believe she can turn things around. Reading the PSI, there's a lot of good qualities and characteristics for her. It looks like she has some education and wants to continue that. But Your Honor, on the flip side of the coin, methamphetamine is a destructive substance. She was facing a 20-year felony in this case. Plea was a huge benefit to her, and we are recommending the 7411 status, but the people would still ask for a short stint in jail, Your Honor, and would leave that amount of time in the court's discretion.
Can I ask you, Mr. McLennan, so, I get a summary of the offense in the pre-sentence report, but I don't have the full benefit, and nor should I, of course, of all of the investigative materials that you and Mr. Vogler had. So when Mr. Vogler says, as he reads this, that there were approaches made to this defendant by the same CI before and after this delivery, and there were refusals of this defendant to facilitate that, and this was the single yes in a series of no's. Is that correct? I don't understand the material.
I don't believe I saw that in the police report, Your Honor. That would be news to me. So I'm not aware of that.
It was our position, Your Honor, and that's a position we took in our motion on that.
Yeah, which, Ms. Parr, for your benefit, I know you're distracted by that.
I'm so sorry.
That doesn't affect what happens right here with you. Okay, it's totally separate. Just for your benefit and perhaps peace of mind, as your attorney outlined that in a motion, that was going to be a heavy lift and probably not successful deliveries where somebody's cajoling somebody to deliver and they finally do. That's very rarely going to be an entrapment. Maybe if it's like, gee, I'm dying of cancer and I need you to give me some of your pills, sort of thing. But methamphetamine doesn't have any those type of
Helping nobody.
Right. All right, but that's a relevant context for the court to think about. So here in this part, we've got, one case, this is a simple case controlled by a meth. We get these all the time. But this is not There's some complicating facts here, one of which is this would be, if you were convicted of delivering methamphetamine. I kind of did a thumbnail on the guidelines, and you'd be looking at 24 to 40 months would be your guidelines range. So that event, if you were convicted as charged, would be the lowest sentence you'd get would be 2 to 20 years in prison. So you got a significant benefit by a reduction to possession. So your range is lower, 0 to 11. And the prosecutor's even offering 7411, which would be a probation that if you successfully complete, then the charge is dismissed. That's a huge benefit to you. You don't have a prior felony conviction, so you could avoid one here. When I look, though, at, and your attorney laid out some reasons why there's some mitigating facts here, and those seem to be accurate. But then, and on 0 to 11, I'm directed by the legislature to consider no jail unless there's reasonable grounds for some incarceration. Here I look at, this was pled down from a delivery, which would have been prison. And also, when I look at your misdemeanor history, I do see where you've been given a lot of chances, and maybe that's caused you to not fully appreciate the seriousness of some things. Your criminal record is an embezzlement where you got fines and costs, a misdemeanor. A misdemeanor bad check case, fines and costs. A misdemeanor no security, fines and costs. A misdemeanor drunk driving with a child, 15 days jail. Shoplifting, 15 days jail. A second offense, drunk driving, 5 days jail. A DWLS, fines and costs. You did get an unsuccessful discharge from sobriety court and 180 days in jail in 2016. So, I do think that there's some incarceration that's appropriate. The question is how much. So taking all these things into account, Ms. Parr, I am going to place you on probation for 24 months, 2 years, subject to the terms and conditions listed on pages 2 and 3 in the pre-sentence report. That'll be under section 7411 of the Public Health Code, so you'll earn a chance to not have the felony if you succeed on probation. There's $68 in state cost, $130 in the crime victims assessment, $350 in state cost. And I'm going to order that you serve 6 months in the Presque County Jail. I'll give you credit for 2 days previously served. That is a sentence within the advisory guidelines around the middle of it. I think as I outlined, there are some reasonable grounds for incarceration. This would be a prison police that should put to possession. And it does have a history of misdemeanor criminal activity. As part of this, the sentence of the court, if you have to, within 24 hours of your release, you have to report to your probation agent. If you wanted to appeal, you can do so by filing an application. If you want a lawyer, I would give you one, but you'd have to ask me within 6 months. So we're going to hand some appeal paperwork to you. Ask you to initial one copy for us. Fill out the other one if you want to take an appeal. And good luck to you, Ms. Parr, on the 7411.
This can't be held above my head over there. I promise there's no thing up from me. I can't.
Ms. Parr, that's the sentence I've pronounced.
Oh, God. Now that I tell my daughter what to do at home or the car, you gotta get
At
it
this
home.
point, you can't have contact with them. You're in custody of the deputy.
Third week, yes, it will, Jason's cell phone.